Miss Aurorah is back. Secured Entrepreneurs, Miss Aurorah told you that I was going to come back with this video concerning this Corporate Transparency Act. And I have answered a few of the emails, okay? And what I want to say before we get this going, all of the secured entrepreneurs, please make sure that we have your best current up-to-date email, because Miss Aurorah is going to be doing a detailed video for all of the secured entrepreneurs to let you know what it is that you may have to do and what it is that you do not have to do, okay? In this video, Miss Aurorah is going to get into the Corporate Transparency Act and the exemptions, okay? And I'm going to let the secured entrepreneurs know where exactly many of us fall in the exemptions, okay? So please be sure to like, share, subscribe if you have not, comment below, okay? So for those of you who do not know who I am Miss Aurorah Dey, and this is the Secured Entrepreneur Movement. So, all right, secured entrepreneurs, Miss Aurorah has read the entire 57-page guide, okay, and has a full understanding of who needs to file and who does not need to file, okay? I want you all to know who were panicking about the file date of January 1, 2024. What you must know is that if your entity is supposed to file, but it was registered before January 1, 2024, you have been extended time. The time that the financial crime, financial crime network people, okay, has given those of us who have entities that were recorded before January 1, 2024, up until January 1, 2025. So that's one thing that you need to know, because many of you are, you got to calm down, you're panicking, okay? All of us here already now, we have registered entities before January 1, 2024. Everyone who has come on board between November and December will have their entities registered before January 1, 2024. Okay? You will not have to file until January 1, 2025. This is in the guide, the 57-page guide. And Ms. Aurorah is going to put all of that information in the description box of this video, okay? Now, for those of you who have a concern about your anonymity, understand that this is not affecting how it is you are conducting your business in commerce. What this is additional monitoring for what they say they want to cut down on financial crimes. They say they want to cut down on money laundering. Okay? I read a whole thing that just, I don't even understand. I do understand it. I'm not in agreement with it. Let me say it that way. So every entrepreneur, small business owner, please read the 57-page guide. And I mean all of it, okay? Now, most of the secured entrepreneurs know Ms. Aurorah will make a phone call in a minute. So, of course, I spoke to an individual at one of the banks that I work closely with. And I made an inquiry about this whole thing. And I asked, what are they really going to consider money laundering? Like, is it going to be a situation where any little thing you do, oh, you're money laundering. Oh, it's a financial crime. You know what I'm saying? And so the young lady told me, she goes, well, from what we're, being told, it's really anything that we would have done before. Anything, if we saw some suspicious activity, we would be alerting the necessary agencies. We might have to alert the customer and ask certain things. Like it's really on the same level. Okay. And she really couldn't tell me too much more. So of course, Miss Aurorah goes fishing to find out what category the secured entrepreneurs fall in. Okay. And there are 3. Out of the 23 exemptions, there are 3 that the secured entrepreneurs would fall under. And this is why I'm asking you to make sure that we have all of your correct information. Please email so that we know. info@AurorahDayConsultant.com. You already know, right? But we're going to try to find as many of you as it relates to the emails as we can to send the detailed video to you. Okay. Because there's some things I'm not going to get into in this video. I just can't. So I want all of these secured entrepreneurs and all of the entrepreneurs who stop by to visit us to know what the 23 exemptions are. Because here's the deal. We all know that here in the secured entrepreneur movement, we believe in privacy, security, and anonymity. I was told, I do not know if this is true. Some secured entrepreneur, please comment below and let me know. I was inquiring about the information on FinCEN being public. I was told that is not going to be public because your filing is already public with the Secretary of State. You have a filing that shows up on the Secretary of State's website. So I'm being told that FinCEN will not be making any of this information public. FinCEN, I'm being told that FinCEN, if somebody were to go to FinCEN and look up, your company, that it's not going to be something that they can do. I do not know if this is true. This is what I'm being told. Any of the secured entrepreneurs, if you found out something different, if you've read something different, comment below. Please let us know. Or you already know, you can send us an email and let us know. Okay. So I want you all to know that beneficial owner, because that's one of the questions. Okay. Because that's what this is all about. We want to know who the beneficial owner is. Well, who is the beneficial owner? Well, the beneficial owner is any individual or group of individuals who are enjoying the benefits of an asset, property, okay, even though the asset or the property is being held in a different name. Okay? So the beneficial owner doesn't really, I don't understand why they're even using that terminology, because their whole thing is they just want to know about any legal entity that had to be filed at the Secretary of State. If you have a legal entity that did not have to be filed at the Secretary of State, they don't want anything to do with you, right? So they're saying basically that whoever owns this company is the beneficial owner. Now, your anonymity, if you are filed in a state, like we use a particular state, I have already called the Secretary of State to make inquiry, and they have assured Ms. Aurorah that their statutes are not changing. They don't have a plan to change the statute, And at the moment that they do, it's going to be an announcement on their website, okay, things of that nature. But they have no intention to change their statute as it relates to anonymity and privacy, the Privacy Act. They don't have an intention to do that. So this will be the FinCEN situation. And I've already explained to the secured entrepreneurs the true reason behind this. And if you missed it, go back to the first video of today, which was watch out for what's about to come now, something like that, whatever it was. Okay, watch that video, 3 a.m. shenanigans, okay? So that's what I want to make clear, that they're asking you about who the beneficial owner is. Now, we know here that it doesn't even matter if, you can say I'm the owner all you want to, because I'm still exempt from taxation because I'm not taking a salary. I'm not paying myself. The company is not paying me. So I still don't have any tax to pay, okay? So here in the secured entrepreneur movement, we already know how to operate properly in commerce via these entities, which is why I was like so excited to read these exemptions, okay? So let Miss Aurorah tell you what the 23 exemptions are in detail, and I'm going to put the explanations in the video when I go back to edit, okay? The first one that I thought was really interesting, which is the securities reporting issuer. So the securities reporting issuer is any issuer of securities that is A, an issuer of a class of securities registered under Section 12 of the Securities Exchange Act of 1934, or B, required to file supplementary and periodic information under Section 15D of the Securities Exchange Act of 1934. So the first thing I immediately noticed is that, well, no, they don't need to do any of that because they're already being monitored. Okay, they're already doing the filing where they're being monitored for a financial crime. Okay. The second one is the governmental authority. And the governmental authority is any entity that A, is established under the laws of the United States, an Indian tribe or state, or a political subdivision of a state, or under an interstate compact between two or more states, and B, exercises governmental authority on behalf of the United States or any such Indian tribe, state, or political subdivision. So here was the obvious. The third one is a bank, right? And so we all know that any bank, as defined in A, Section 3 of the Federal Deposit Insurance Act, B, Section 2A of the Investment Company Act of 1940, or C, Section 202A of the Investment Advisors Act of 1940. Of course, the fourth one is a credit union, right? The credit union. They don't want anything to do with the credit union. Any federal credit union or state credit union, as those terms are defined in Section 101 of the Federal Credit Union Act. The fifth one is the Depository Institution Holding Company. And for those of you who do not know what that is about, that's any bank holding company as defined in Section 2 of the Bank Holding Company Act of 1956, or any savings and loan holding company as defined in Section 10A of the Homeowners Loan Act. And then the sixth one is money service business, and that's any money transmitting business registered with FinCEN under 31 USC 5330, and any money services business registered with FinCEN under 31 CFR 1022.380. The seventh one is a broker or a dealer in securities. So that's any broker or dealer as those terms are defined in Section 3 of the Securities Exchange Act of 1934 that is registered under Section 15 of that act. The eighth one is securities exchange or clearing agency. So that's any exchange or clearing agency as those terms are defined in Section 3 of the Securities Exchange Act of 1934 that is registered under Section 6 or 17A of that act. Number 9 is other Exchange Act registered entity. So that's any entity other than that described in Exemption 1. Securities reporting issuer. Exemption 7, broker or dealer in securities. Or Exemption 8, securities exchange or clearing agency that is registered with the SEC under the Securities Exchange Act of 1934. Number 10 is investment company or investment advisor. So that's any entity that is A, an investment company as defined in Section 3 of the Investment Company Act of 1940, or is an investment advisor as defined in Section 202 of the Investment Advisors Act of 1940. Number 11 is venture capital fund advisor. So that's any investment advisor that A, is described in Section 203I of the Investment Advisors Act of 1940, and B, has filed Item 10, Schedule A and Schedule B of Part 1A of Form ADV or any successor thereto with the SEC. And of course, you can't be surprised by number 12. That's an insurance company. Okay. So that's any insurance company as defined in Section 2 of the Investment Company Act of 1940. Number 13 is state licensed insurance producer. So that's any entity that A, is an insurance producer that is authorized by a state and subject to supervision by the insurance commissioner or a similar official or agency of a state, and B, has an operating presence at a physical office within the United States. Number 14 is a Commodity Exchange Act registered entity. And that's any entity that A, is registered entity as defined in Section 1A of the Commodity Exchange Act, or B, is 1, a futures commission merchant, introducing broker, swap dealer, major swap participant, commodity pool operator, or commodity trading advisor, each as defined in Section 1A of the Commodity Exchange Act, or a retail foreign exchange dealer as described in Section 2C, 2B of the Commodity Exchange Act, and 2, registered with the Commodity Futures Trading Commission under the Commodity Exchange Act. Of course, number 15 is an accounting firm. So that's any public accounting firm registered in accordance with Section 102, the Sarbanes-Oxley Act of 2002. 16 is a public utility. So that's any entity that is a regulated public utility as defined in 26 U.S.C. 7701A33A that provides telecommunications services, electrical power, natural gas or water, and sewer services within the United States. 17 is a financial market utility. And so that's any financial market utility designated by the Financial Stability Oversight Council under Section 804 of the Payment, Clearing, and Settlement Supervision Act of 2010. Number 18 is a pooled investment vehicle. And so that's any pooled investment vehicle that is operated or advised by a person described in exemptions 3, which is a bank, 4, which is a credit union, 7, which is the broker or dealer in securities, 10, which is the investment company or investment advisor, or 11, venture capital fund advisor. Now, secured entrepreneurs. This is where many of us now get in where we fit in for the exemption. And again, please make sure we have your information because Ms. Aurorah is going to go in with a detailed video that I'm sending only to the secured entrepreneurs. Okay. So the next one is a tax exempt entity. A tax exempt entity. Any entity that is A, an organization that is described in Section 501C of the Internal Revenue Code of 1986, determined without regard to Section 508A of the Code, and exempt from tax under Section 501A of the Code, except that in the case of any such organization that ceases to be described in Section 501C and exempt from tax under Section 501A, such organization shall be considered to continue to be described as a tax-exempt entity for the 180-day period beginning on the date of the loss of such tax-exempt status. B, a political organization as defined in Section 527E1 of the Code that is exempt from tax under Section 527A of the Code, or C, a trust described in paragraph 1 or 2 of Section 4947A of the Code. Ms. Aurorah will discuss that in the video that we're sending to the secured entrepreneurs. Okay, this one is really for us. It's juicy. Number 20 is an entity that is assisting a tax exempt entity. I wanted to make some noise. Okay, because they have all our sweet spots. I'm like, wow, this is amazing. Okay, so let's talk about this entity. They say that an entity assisting a tax-exempt entity is any entity that operates exclusively to provide financial assistance to or hold governance rights over any entity described in Exemption 19 above. Tax-exempt entity. B, is a United States person. C, is beneficially owned or controlled exclusively by one or more United States persons that are United States citizens or lawfully admitted for permanent residence. And D, derives at states citizens or lawfully admitted for permanent residence. Now, 21 is really quite comical to me. It's large operating company, and they describe this as any entity that A, employs more than 20 full-time employees in the United States, with full-time employee in the United States having the meaning provided in 26 CFR 54.4980H-1A and 54.4980H-3, except that the term United States, as used in those sections of the CFR, have the meaning provided in 31 CFR 1010.100HHH. B, has an operating presence at a physical office within the United States. And C, filed a federal income tax or information return in the United States for the previous year demonstrating more than $5 million in gross receipts or sales, as reported as gross receipts or sales, net of returns and allowances, on the entity's IRS Form 1120, Consolidated IRS Form 1120, IRS Form 1120S, IRS Form 1065, or other applicable IRS form, excluding gross receipts or sales from sources outside the United States, as determined under federal income tax principles for an entity that is part of an affiliated group of corporations within the meaning of 26 U.S.C. 1504 that filed a consolidated return. The applicable amount shall be the amount reported on the consolidated return for such group. All right, many of us are going to fall into 22, which happens to be subsidiaries of certain tax-exempt entities. And so they're saying that that's any entity whose ownership interests are controlled, are wholly owned directly or indirectly by one or more entities described in exemptions 1, 2, 3, 4, 5, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 19, or 21 set forth above. Now, we know that there's a whole lot of people who have number 23, which is an inactive entity. Okay, so they're telling us that as far as they're concerned, an inactive entity is any entity that A, was in existence on or before January 1, 2020. B, is not engaged in active business. C, is not owned by a foreign person, whether directly or indirectly, wholly or partially. D, has not experienced any change in ownership in the preceding 12-month period. E, has not sent or received any funds in an amount greater than $1,000, either directly or through any financial account in which the entity or any affiliate of the entity had an interest in the preceding 12-month period. And F, does not otherwise hold any kind of type of assets, whether in the United States or abroad, including any ownership interest in any corporation, limited liability company, or other similar entity. Now, Ms. Aurorah believes that the guide has made it ultra clear who is exempt. They even have a little map. I might put it in the video. I thought it was so cute, to assist people who really don't understand that this is not rocket science. We want you to send us this report if you have a legal entity that you registered with the Secretary of State. And then they give you these exemptions. Oh, well, if you're this business, then okay, that's not you. But as you heard from all 23, those are businesses who already know I have a filing with the Securities Exchange Commission. I don't fall into that category, okay? So I don't want the secured entrepreneurs to start freaking out about what it is that you have to do. Now, I was looking to see if in fact you don't file because you know that you're exempt, what happens there and all that stuff. They don't have anything that I'm seeing right now to say, okay, this is my entity, I don't have to file. Okay, clearly they're leaving it up to people to make the determination, seeing as they have given you the 23 exemptions. Okay, so I don't see anything there just yet. If I do, I will come and tell y'all in one of the morning videos when I come in the morning to talk about it, but I have not seen anything yet. So just to reiterate, any entity that was registered before January 1, 2024, you have until January 1, 2025 to file. Any entity that is registered after January 1, 2024 has 90 days to file. Now, they have some penalties imposed if you know that you're not exempt and you neglect to file. Okay? But I believe that those things can be worked out. Okay? So, secured entrepreneurs, please look out for an email by Friday. I will be giving a very detailed video. I'm going to make a very detailed video for you all. And then I'm sure most of you will need to get onto the calendar. So you already know, send the email and Jessica will make sure that we have an appointment to discuss your entities and the wealth cycle that you are in and how it is we're going to create the scenario for you to fall into one of the exempt categories, simply because we have been working with the right entities from day one. So we don't have to worry. All right. So anyone who has stopped by to watch this video, if you want to learn more about how it is we do what we do here in the Secured Entrepreneur Movement as it relates to mastering tax-free wealth, you can go down in the description bar and click on the link to watch the training. Okay, I think it's like 17 minutes or something like that. All right. And if you feel the need to get your legal entities started before the first, okay, and the right way so that you don't have to be bothered with this, you already know you can get onto the calendar. All right. So that's what Miss Aurorah wants to share in this video. And please comment below, put your questions or send your questions via email. All right. So you already know that you can find me, Miss Aurorah Dey, at AurorahDayConsulting.com. And until next time, ta-ta.